Welcome everybody to our Freeth's webinar on the Planning and Infrastructure Bill, and specifically Part 3, and looking at the government's amendments to that bill. It seems like we've been talking about this bill for quite a long time. I think this is our third webinar. I hope some of you will have seen the previous ones. Today we're focusing on the government amendments that were put forward in July, and I'll be presenting together with Richard Broadbent, my colleague, who's on the screen now.
Hi,
I'm a
everyone.
partner in the Freeth's Environment team. I lead the team, and Richard is our director in the Environment team. And we also have with us Katie Proctor, who's our legal assistant, works with me specifically in Sheffield, although we have our team spread across 3 offices. So, thanks everyone. I'm going to pass over to Richard. He's going to introduce some of the background to the bill, and then we're going to have a discussion, he and I, about it, and then we'll have questions at the end for about 10 minutes. So we'll be speaking for about 35 minutes, we think, and then questions. Okay, Richard.
Great. Well, thank you, Penny, and lovely to be speaking with you all again on this important topic. So as Penny said, before we get into the government's amendments, which is the meat of the discussion today, we're going to just recap a little bit, provide an overview of what the Planning and Infrastructure Bill does to make sure we're all on the same page about that, and then consider the progress of the bill so far and how these amendments came about. So the first thing to acknowledge about the Planning Infrastructure Bill, Part 3, what it does, what it creates, is this new pay-and-go system for specific development impacts on certain environmental features. So it's not a system that blows away all of environmental law. It is for specific things covered by these environmental delivery plans, specific development and specific impacts associated with that. And that will apply to the key nature conservation protections under law in this country, which is protected sites and protected species. And that will happen through the payment into a nature restoration fund. That will happen through a levy that will be imposed on developers, a new sort of development tax. And that will fund these new conservation measures for protected sites and species. And I quite like this diagram, so we're going to go through it again with you all. But this is a diagram that sort of schematically shows you how this will operate. So this all starts off with Natural England. It's a very sort of Natural England-led process, this. Natural England will work on the preparation of an environmental delivery plan. They'll consider the impacts of a particular development on the environment. They will consult on that, work on that, and then submit that to the Secretary of State, MHCLG here, and the Secretary of State will sign it off. So that the legal tests under Part 3 bite on the Secretary of State. They're the ones who are signing off on these environmental delivery plans, but they are prepared by Natural England. Then that plan is published. So what happens then? Well, if you're a developer, there are sort of 2 broad options. So option 1 is you're a developer who's lucky enough to be covered by one of these new environmental delivery plans. So what happens in that situation? And then option 2 is if you're a developer who is not covered by one of these environmental delivery plans, what happens there. So let's look at option 1 first. Under option 1, you can opt in or opt out of this new process. You can do that unless Natural England specifies in the plan that it's mandatory that you pay into this new nature restoration fund. So let's say you opt in. If you opt in, and this will only cover those impacts of your development which are covered by the environmental delivery plan. So if there are other impacts associated with your development then which are not covered by the plan, well, then you'll have to deal with those separately. But if there are certain impacts which are covered, so the classic one here which they're trying to address is, say, nutrients and the impacts of nutrients from new development in areas which are affected by diffuse pollution, well, then you pay into this new piggy bank that's created called a Nature Restoration Fund. And then Natural England, having prepared the plan and submitted it to the Secretary of State, that is then for Natural England to draw down from that piggy bank to deliver the conservation measures under the environmental delivery plan. Or if those impacts are on species, then that environmental delivery plan becomes effectively your license for those impacts on species. Or Natural England can pay others to do that, to deliver those conservation measures for them. So that could be landowners, or it could be NGOs. It depends on who it decides to allocate the funding to. If you decide to opt out of this new process, then the developer simply complies with the law as it currently stands. And that means if they have compensation or mitigation impacts that they need to have addressed, well, then they can deal with those in the normal way, either by buying the nutrient credits they need, for example, from the market, or by applying to Natural England for a species license that they need. And if under option 2, you're a developer who's not covered by an environmental delivery plan, well, it's absolutely the same as it was before. No change there. So that's, broadly speaking, what we're looking at here. So let's look at the progress of the bill then, and what's been going on over the last few months. So the bill has moved through the House of Commons and now moved into the House of Lords, and it started in its committee stage in July. We then went into the summer recess, and then now that the Parliament's back in session, it is continuing to go through the committee stage. Now, the amendments that we're going to talk about today landed when this went to committee in the House of Lords. That's that 17th of July date that you can see there. And so those amendments will now be properly scrutinized through that committee stage. And then following that, there'll be a report stage on this from the House of Lords, then the third reading, and then it goes into this process of ping pong, whereby the House of Commons and the House of Lords agree on the wording, the final wording of the bill, and that will take as long as it takes. One of the questions we received in advance of this session was, how long might it be until royal assent is provided? I'm not sure. November, October seems to be a sensible guess here. I think a key point to make here is Part 3 is going to happen. There was some thought that it might be put on pause and might be pulled. I don't think so. It looks like it's going to happen in one shape or form or another, and it just what matters now is to what extent it's going to be amended, in essence. Okay.
And it might just be worth saying that although it'll happen, when it actually bites will be when the first EDP is made.
Absolutely right.
So we don't know when that will be. So just because we get royal assent in November, let's say, doesn't automatically mean things change. It will depend on when the first EDP is
Exactly.
made.
And there'll be secondary legislation, an EDP will
Yeah.
need to be drafted, and so it'll take some time for this to work its way through the system. Absolutely right.
Yeah.
Okay, so there's been some controversy over this, and controversy which has led to these amendments, and these amendments in the form in which we've seen them. And that kind of started around April, when this went through the committee stage in the House of Commons. And there, for example, various parties gave evidence on the bill, one of which was Richard Benwell, who's the chief executive of Countryside Link, who gave very strong submissions about the need for the the Part 3 not to be regressive, that you can have environment and development, and that you need to strengthen up Part 3 to make it actually work for both the environment and for development. Setting a tone that this is obviously we're not going to stop government doing this, but we can try and amend this to make it slightly more palatable. Other controversy, for example, was when Marion Spain, Chief Executive of Natural England, was giving evidence at the committee, and there was this discussion over the mitigation hierarchy. And Marion was saying, no, the mitigation hierarchy is actually part of this. But if you look at the bill, something that's fundamental in mitigation hierarchy looked like it wasn't there. So concerns over something as fundamental and quite as basic to environmental law and policy as mitigation hierarchy, again, caused controversy. There was things like a letter which was signed by people like Sir John Lawton, Caroline Lucas, Professor Siddhartha Dasgupta, Ben Goldsmith, Isabella Tree, a letter to government saying under these proposals, Natural England will be deeply conflicted because it's meant to be protecting the environment, and yet it's getting money in order for development to be unlocked in these ways, and that Natural England, government policies requiring Natural England to regulate for growth, not the environment. So this was the start of a concerted pushback, not to stop Part 3, but to try and improve it. And what also added particular fuel to this was a letter from the Office for Environmental Protection on Part 3. And a key passage from this is, their concern that the bill, as it was originally published, would reduce the level of environmental protection provided for by existing environmental law. That in effect, Part 3 was a regression in environmental standards. And it was the OEP's intervention, for example, in the Levelling Up and Regeneration bill, and it became an act, which tried to sort of tear a hole in the habitats regulations, again, over nutrient neutrality. It was the OEP's intervention over that meant that the government got defeated on those amendments. That was a couple of years ago. So the OEP's intervention here was really quite important and stark in the way that this unfolded. All of this gathered momentum. And in July, we see these amendments, and those amendments were moved by Baroness Taylor of Stevenage, who's the Parliamentary Undersecretary of State at MHCLG. And the reception that of those amendments has been mixed, it's fair to say, from the ENGO and from this sector. So, and at the same time that those amendments were published, MHCLG also provided some guidance on these amendments, trying to explain what they were doing and the purpose behind them, also published on the 17th of July. And what they said here is, we want to ensure that everyone has confidence in the new Nature Recovery Fund. They wanted to make sure that people understand that it will deliver, that they had engaged with stakeholders. And of course, this followed this process through the committee where there was this sort of intense scrutiny of Part 3. They said that they've provided this comprehensive set of amendments, which they said will provide reassurance that the NRF will restore, not harm nature, while at the same time ensuring house builders benefit from the same streamlined process. So this is the government saying, hey, okay, so you've told us that there's a concern with this, and we've now fixed the concern through these amendments. And then we entered into the summer period. So just after these amendments were published, the Chancellor said in the House of Lords Economic Affairs Committee, I care more about young families getting on the housing ladder than I do care about some snails, that we've cared more about bats in this country than about the commuters over infrastructure being built. And
I don't think all the pictures have come up, Richard. I don't know whether
and then
yeah,
sure. And then in August, we saw a briefing from the Treasury saying that Rachel Reeves wants to cut bats and newts to boost development. So there was a suggestion that there would be another planning bill in addition to Part 3, which would go even further in terms of pushing back on environmental protections. And there was talk about this abolishing the precautionary principle. The Treasury is saying that they wanted the more contentious set of reforms, tearing up key parts of European environmental rules that developers say are making it harder to build key projects. And as soon as that happened, the day after that, there was a threat of legal action from the Better Planning Coalition, if that happens. And it's not unusual for Treasury to float ideas, policy ideas, particularly during August, in preparation for autumn and the budget and so on. But this was, I think, a particular surprise. And again, it was from the Treasury that we saw a lot of this anti-environment rhetoric through from autumn last year onwards. And again, that sort of flared up over the summer, and the NGOs were quick to sort of push back on that. So that's the story so far. And I was going to leave it there for this presentation, but of course, there's been more news. So last week, of course, we saw that the Secretary of State for MHCLG, Angela Rayner, who's the sponsor of this bill, had to resign. And that Steve Reed, the Secretary of State for DEFRA, who's been working very closely, obviously DEFRA's been working very closely with MHCLG on Part 3, has been named the new Secretary of State. So presumably it will be business as usual with the bill. It will continue because Steve Reed is behind it as much as Angela Rayner, I would imagine, given that Natural England is essentially becoming a delivery body of MHCLG under Part 3. And we have a new Secretary of State at DEFRA, Emma Reynolds, who's come over from the Treasury. And of course, it was the Treasury that was pushing out these anti-environmental law sort of sound bites through the summer. So maybe we'll see business as usual there. Don't know. But that's a big political shake-up insofar as Part 3 is concerned. Okay, so that's a little recap of what the bill covers and the story so far. And what we're going to do now is get into the meat of the discussion today, which is, well, let's just look at these amendments and kind of look at them in turn, break them apart a little bit and scrutinize them. And we're helped here by the publication just last week of David Elving KC's second legal opinion on Part 3 and on these amendments. He did a first legal opinion some months ago now, but now there's a fresh second opinion which focuses in on these amendments, and that was provided on behalf of our clients, NatureSpace. And there was some press about that last week. And spoiler alert, if you haven't read that yet, is David thinks that Part 3, even with these amendments, is still a regression. So what we're going to look at, Penny and I, now is kind of break these amendments up into two parts. Process amendments, which are softer edged, and outcome amendments, which are harder edged. And what do you want to explain what we mean by that, Penny?
Yeah, sure. Okay. So in environmental law, there are certain provisions in legislation which direct to a certain outcome. So an example would be, in the existing system of protection for, let's say, European protected species, the idea is that you mustn't harm them, but if you do, that you should at least be licensed, and in doing that, ensure no detriment to the favourable conservation status of the protected species. So that's very clearly an outcome that you have to secure. Similarly, for European sites, there's the outcome of no adverse effects on integrity, and we know that case law requires a high standard for that. So these are the outcomes that environmental law traditionally has provided for. But
Yeah.
there's it's sort of noticeable in this bill that a lot of the amendments are not obviously to do with outcomes in an environmental standard way, which is perhaps what many people would want to see to kind of address the regression issues.
Mm.
And instead, the amendments many of them are to do with a process. So making a comment on something that must happen, but not necessarily leading to any particular outcome. So this is the way we wanted to explain the amendments to you. There are some amendments, well, you'll see, most of them are to do with process points, which are
Absolutely.
kind of
The vast
interesting, but
majority.
the
Yeah.
vast majority, yeah, they're interesting, but they don't necessarily deliver for the environment. And the outcome amendments are rather few and far between, which won't be a surprise to many of you. But this is the kind of distinction between the two different types of amendments.
Yeah.
And Richard, I know you've been listening to academics in environmental law talking about how this is something that's been happening more and more.
Yeah, and it's a trend, I guess, in other areas, but we definitely see it here, and it's a trend that's a move from um, uh, environmental law, which is based on evidence-based principles, a set of hurdles that have to be overcome, and replacing that with a much more discretionary, personal decision made by a politician. So in this case, a Secretary of State. And in
Yeah,
fact, if you read David Alvin Casey's second opinion, he says, you're losing this mandatory set of hurdles and it's being replaced with this discretionary test. And that discretionary test is what the first one we're going
yeah.
to talk about next. And
So
that's quite a big thing, because it's very procedural, isn't it, the habitats regulations, and we're kind of
yeah.
losing that.
And so what we're saying is that even the outcome amendments in this bill are
Yeah.
still amendments that in the end come down to the decision of one individual,
Yes.
an
Yeah.
elected individual. And that is not obviously as robust as a system whereby the legislation explains the steps that have to be met to get to a particular decision, and therefore makes that decision more, I suppose, transparent and evidence-based. So yeah,
Yeah. And
but
none of these amendments fundamentally do away with it. This is a sea change in the way we do things. That's what this, and the amendments change elements of that. And by all means, the ENGOs have done a great deal to secure these, because I didn't think going into this that we would get these amendments. So they've achieved a great deal, and that's really good. But it's a fundamental sea change in what we have here, and these amendments don't change that. The this new way of doing things is what we see here. So should we look then, first of all, at the outcome ones? These are the more hard-edged, meaningful ones, amendments, and let's see
yeah,
what
just
this
before we say
says.
that, just want
Yeah,
to say that David Elvin's opinion, if you want to read it, is on the Nature Space website.
yeah, absolutely.
Okay, so yeah, the outcome amendments, yeah.
So the first one here is the EDP overall improvement test. That's this new discretionary test that the Secretary of State has when they when they decide whether to make these environmental delivery plans, which have been prepared for them by Natural England. And so there was concern about that test. And so what this amendment is to change that so that conservation measures by the end date of the environmental delivery plan must materially outweigh, there's the amended wording, the negative impact of development on the conservation status of each environmental feature. And that government said is to give people reassurance that it will actually deliver. So this is a sort of move to try and beef up this new test. And what are your thoughts on that, Penny?
Yes, so the previous wording was likely to outweigh. So now we have a must materially outweigh from a likely outweighing. So that's an improvement for sure. In the end, though, it is about judgment of an individual
Yeah,
without a particular set of rules confining that judgment. And so it's a judgment that will be made and will be quite difficult to question or to criticize because
because it's aspirational too. It's like, I know, I believe it will by the end of the period, you know. So
yeah,
if you're in an aspirational frame of mind when you make that decision, well, then sure,
yeah.
you can pass it. And it'll be
Yeah,
very difficult to challenge you on that because it was just your opinion that it would achieve that.
exactly. Yeah. So
And against a low baseline too, because it's the baseline of this is the conservation, you know, the environmental standards at the point at which it starts as well, not a previous one. So it's
yeah, that's right.
at a
The
degraded baseline.
the word conservation status here is a reference, it seems, to the status at the time the EDP is written.
Mm,
So it's actually when the EDP, yeah, the EDP start date. I'm just looking at the legislation. So yes, it's not taking into account losses that have occurred over many years to date. So yeah, it's an improvement, but it's not in any way the strict tests we've had for species and habitats through the Habitats Directive, for sure.
that's right, because we're losing that standard of proof of beyond all reasonable scientific doubt. That's what we
Yeah,
have currently. And we're replacing with this, which can be construed in a more aspirational way with a reduced baseline and all the rest of it. So it's better and it's more reassuring, but it doesn't fundamentally change the picture, you'd say.
yeah,
Okay, so that's the first one. Next one up then is an EDP which seeks to improve the conservation of the same protected site feature elsewhere. Um, and this is an amendment which was made to address that controversy over part three missing the mitigation hierarchy. So
yeah.
this is to plug the mitigation hierarchy gap again, which is a fundamental concept in environmental law and policy. So what are your thoughts on that one, Penny?
So basically, it's saying that if you do want to go away from the site of impact in terms of your conservation measures, you can only do that where Natural England has considered that that off-site approach would be better for the conservation status of the feature than the on-site measure would be. So it is effectively giving a check to going off-site,
Yeah,
which is again an improvement. It's not as, I suppose, robust as the mitigation hierarchy. It's not making a distinction between avoidance and mitigation, and then from mitigation to compensation. It's just looking at the difference between mitigation and compensation. And it's it's again a judgment of Natural England
yeah,
without any particular constraints or explanation as to how they come to that decision.
yeah,
So it does provide a little bit of a comma before they rush to deliver off-site measures, but it's not quite the robustness that we've had before. And
exactly.
certainly, of course, if you think about the hierarchy in terms of the Habitats Directive, many of you will know that to go to compensation, you have to also address questions of alternatives and need, both when
Yeah,
it comes to sites and for species. And that part, the question of alternatives, do we have to do this, or is there an alternative? That's not there. The other thing
mm,
is that this is actually only about protected sites.
yes,
It's not about this requirement to be sure that there must be a greater contribution to the conservation status is not about species, it's only about sites. It's a bit odd because actually for species we have actually already in some ways through, for example, the Natural England licensing policies that apply to European protected species, we have actually in some ways slightly blurred the distinctions between mitigation and compensation because for example, you can deliver off-site compensation if it's better overall for the species than mitigation. That's one of the licensing policies, but that isn't actually reflected in this bill. I don't think that will stop them adopting that approach, but yeah.
Yeah.
Okay, next one.
So this is the next key outcome amendment, and that is remedial action. So this concern that, okay, so if these conservation measures set out in the environmental delivery plan look like they're not going to achieve what they're meant to achieve or are failing to achieve it, well, then you can bring in this remedial action so based on reporting. So yeah, what are your thoughts on that one, Penny?
Well, so it is an outcome because there has to be now proportionate remedial action. So that is a good step. But the main problem with it is that, as you can see at the bottom of the page, the cost of the remedial action is relevant to whether it's proportionate or not.
Yeah.
Which I suppose isn't particularly surprising, but it means that whilst remedial action may be something that they think about, in the end, it may not be comprehensive to deal with whatever the impacts are. So that's the main problem with it. It's watered down for that reason.
Yeah.
And if you compare that with, let's say, compensation in species or habitats law, currently there is no cost. Well, yeah, there is no cost element expressly in there, so that is a weaker system.
And it feels quite reactive too. And one of the things that David Elvin talks about in his second opinion is, by the point that you're aware of this and deploy the remedial action, well, the ecosystem could already be irreparably harmed. That could already be the case. And if that's the case, it's exceptionally difficult then to right the ship. And the whole point about the HABs regs at the moment is it's very front loaded. You're trying to really drill down into what your impacts might be, and you're mitigating for those and making sure those problems don't occur. You're trying to avoid time lag so far as possible, all of that sort of stuff. But this seems like, okay, we're going to report and see to what extent this is working. And if it's not working, well, then we'll kick in these remedial actions, provided they don't cost too much. And that's, that feels too reactive in my view. So this is better. This is certainly better than what we had originally when Part 3 was published and the government said that there was no regression in the environmental standards. So this improves the situation, but it's not what we've got currently, it seems. So that's it. Those are all the outcome amendments that we were able to find. There's 3 of them essentially. And then what we do now is we move into process amendments, and there's many more of these, and some of these are designed to support these outcome amendments, and then and provide a little bit more process around this, sort of shoehorning back into Part 3 the process that that we currently have and are losing.
It's worth just saying that when you have process requirements, they do need to, that does mean that they have to be followed. So if in the process they were not followed, so we're going to go through all the amendments that are extra steps that have now been built in to the process. But if you didn't, if one of the steps was not taken, then that would be a problem, and it would give rise to a judicial review potentially of the resulting environmental delivery plan. So you might say, oh, well, this does make it more robust because you can challenge the plan if the process isn't followed. And that's true, but to what end? Because the court might well say, well, correct, the process wasn't followed, but actually, if it had been followed, perhaps the result would have been the same anyway, so why are we worrying about it? Or they might say, well, go away and redo the process and do it correctly, but the outcome might well still be the same, probably would be. So, this is the problem with these types of amendments. They're giving the impression of a more robust system, but the actual result for the environment is very questionable.
Yeah. So let's go through these then. So the first one up is that Natural England, the EDPs must contain Natural England's opinion on how the conservation measures pass the overall improvement test, and how the protected site off-site measures. So this is where you're looking off-site to deliver your conservation measures rather than the site that's actually been impacted, make a greater contribution to improving that conservation status. So the first one provides a little bit more accountability. You get Natural England's view on this, and that provides a little bit more scrutiny as to that. And the second one supports that new amendment that's being made to plug the gap in, with the mitigation hierarchy. It sort of supports that. Any more thoughts on that, on these ones,
Well,
Penny?
again, it'll be good to see Natural England's opinion written down. The fact they have
Yeah,
to write it down will perhaps focus their minds and enable them to explain why they feel that the overall improvement test is met through the conservation measures that they wish to put forward. And it will help the Secretary of State come to his view when he decides or she decides that, that overall improvement test is met, so the material outweighing is there. But it is an opinion, and again, it goes back to what we said a few minutes ago. It's not an opinion that's very easily challenged, because the factors that go into it are less clear in this system than they are in the systems we've been used to.
exactly right. So the next one up is ADP must provide sequencing of conservation measure implementation. So this is uh, the sequence with which they come through, and this was to address a concern that came up again in committee, which was that the part 3, as it was published originally, would allow for time lags. You could have the impact from development before the conservation measure
Yeah,
kicked in. So this is to try and add a little bit more reassurance that sequencing will be addressed, so that that isn't an issue.
yeah. So sequencing is great, but it doesn't say what the sequence must be. All the sequencing could be right at the end of the 10 years and
Yeah,
this would be met. It just says you've got
exactly.
to tell us what the sequence is. It doesn't say
Yeah.
we've got to get things in place before impacts happen or anything like
No,
that.
you just have
So,
to explain how it's
so
going to happen. Yeah,
yeah,
there's something that bites on that. And the next one up is an EDP must include backup conservation measures. So they're not expected to be needed, because the conservation measures should be what's needed to deliver, but they can be implemented in circumstances set out in the EDP. And it's linked to essentially to monitoring. So
mm,
it's a little bit more in these EDPs about what they will contain. I mean, I got to be frank with you, it's a little bit worrying that these backup measures would be needed, because the conservation measures might not work. But in any
mm,
case, it makes sense to have a plan B if you need it. But these EDPs now contain this plan B.
yeah. Let's move on because I'm noticing the time.
Yeah,
Yeah.
exactly.
Okay.
So the next one is when preparing, amending, revoking an EDP, but not making. So preparing, amending, revoking, that's the sort of working on an EDP, but not when the Secretary of State makes their decision to make the EDP. And that's the key distinction. Um, and also when considering remedial action, the Secretary of State and Natural England must take into account best available scientific evidence. And this is to try and address that concern that we have a current process which is very science-based, and this is to try and provide reassurance about that. But I guess the fatal gap here, Penny, is that best available scientific evidence can be taken into account in the preparing, amending, and revoking of the EDP, but the Secretary of State doesn't need to take that into account when they make the EDP.
It's absolutely extraordinary, this gap, isn't it?
It must be
We just couldn't,
deliberate,
well, we
right?
couldn't believe it when we realized this, could we, Richard? I mean, what's going on there? It just seems like weasel words, and it doesn't really make sense unless you're deliberately hoping the Secretary of State cannot have to take into account best available scientific evidence. So yeah, one to think about, but I suppose they might say, well, Natural England has to take into account when they're preparing it, and therefore it
It
will
would be then a
naturally be
material
taken into account.
consideration which we have to take into account. Yeah,
Yeah,
exactly. But
but why haven't they made it clear? It's very odd and a very
yeah,
worrying gap. Yeah.
and so that's the kind of thing that creates these sort of lingering concerns about this. Another set of procedural amendments then are Natural England and the Secretary of State must have regard to when preparing, amending, revoking EDP, but not making an EDP, when considering remedial action, what Natural England, so they must have regard to various things when they're preparing, amending, revoking, but not making an EDP, and when they're doing remedial action. So what are those things they must have regard to? So it's various plans, such as development plans, the environmental improvement plan, marine plans. They need to take into account conservation objectives, and we see conservation objectives as a concept come back into the legislation now from the habitats regulations. They need to take into account overall coherence of the relevant site network. That's useful when considering off-site impacts. You're taking that holistic view, and need to take into account the species favorable conservation status. Again, a concept taken from the habitats regulations and put back into. So these are amendments to try and repair part 3 so that it looks a bit more like what we currently have with regard to conservation objectives and so on. But it's a weak duty, right, Penny? have regard?
Yeah, well, it's only to have regard, and we all know that that is just to think about. It doesn't mean you have to achieve it.
Mm,
And again, the gap is that it doesn't apply to somebody, to the Secretary of State when making the EDP. It's And so I've just seen a flash up at one of the questions that's come in, and the difference between preparing. So Natural England prepares the EDP, and then they put it forward to the Secretary of State, and they then make the EDP. And
yeah,
the making is what makes the EDP come live. Natural
exactly
England
right.
preparing doesn't matter. So Natural England has to have regard to this stuff when it prepares the EDP, but when the Secretary of State makes it, that's the point we're making, that
Mm,
these things aren't having to be considered, which is
yeah.
odd. So, but yeah, I mean, it's nice that these things have been thrown in. Uh, Unfortunately, they haven't defined favourable conservation status, so that's a bit confusing. But it's something, but for the reasons we've just said, it's not going very far.
And just to pick up on something that was said in that really helpful SAIM webinar on part 3 last week,
Indeed.
so you can have regard to the development plan in the development area, but when you make the EDP, you don't need to follow that. It's have regard anyway, and then that can create a tension between local planning policy and the EDP, and it may mean that the LPA might not want to give planning permission because they don't have confidence in the EDP, and that's setting up a conflict there potentially down the line, and that's something to be aware of, and which was flagged by SAIM, and I thought that was quite interesting. Okay, so then we have amendments around monitoring, and that's again helpful to see. Um, so
Yeah, except as we've noticed, it doesn't
sorry.
actually require Natural England to monitor. It's really
No,
weird. There's actually not actually an absolute requirement, so you're
yeah,
left
it's just a
wondering
function, isn't it? It's not
what
a
this
duty to
means.
monitor.
Yeah.
Yeah, but monitoring, so that's good. That's been beefed up. Um, but it suggests that there may be concerns over whether they might, deliver or not. And then we get these reports. So this monitoring informs these reports which are produced. So Natural England produces midpoint, final, and revocation reports, and those must include an assessment of whether the EDP is likely to pass or has passed the overall improvement test. And if it hasn't passed or isn't likely to pass, the extent to which the conservation measures have failed to meet the overall improvement test. So that's so Natural England, having looked at these monitoring information, then produces these reports at certain times and provides that information. And what you have, we tried to map this out, didn't we, to try and make sense of this. But you have these final and revocation ED reports. And 6 months after that, the Secretary has to provide a statement on what remedial action they're going to provide. And then within 2 years of that, the Secretary reports on remedial action effects and how well they've worked or not. And then further on from that, an unspecified time period, they report on those remedial action
But
effects.
they only do the last bit if the first green bit says that they haven't actually achieved the remedial
Yeah,
action as they had expected, then they have to report again. So I mean, this is a process which is, quite nice. It's Natural England says there are some problems. They say what they're going to do to address it. That's the purple box. Then they report on what they've done and report again if it takes longer than they think. So, quite nice process. But it what happens if at the end of all that we still haven't got them?
exactly. Yeah, no, that's the real concern here. And then
Yeah.
finally, just to wrap up before we go to questions, one further point that was made in this MHCLG statement was, hey, look, don't worry, because the environmental principles policy statement, which the Environment Act creates and which ministers must have regard to, there's a duty on that, on ministers have regard to that when they are um, preparing legislation. The MHCLG said, well, hey, look, those environmental principles, including prevention, rectification, the source, proportion principle, must be considered by Natural England in preparation of the EDP because the Secretary has to take those into account. So that gives you additional reassurance that we're not, going off the reservation here in terms of environmental law and policy. However, we've looked at that, and this again comes up in the second opinion by David Elvin. And that talks about case law showing that that Section 19 duty that they refer to there is really quite weak, isn't it?
Yeah, I think the next slide, the next bullet points just show, because a recent judge has told us that it's not a duty to achieve a particular result or outcome. It's for the minister to decide how much weight to give to the relevant matters. So this duty that MHCLG is pinning all its hopes on is just, you know, basically a matter of judgment again.
Yeah. So
And
even
so
though
as
you could take it into account, it doesn't really shift the
yeah,
dial particularly. It's still a discretionary
yeah,
thing. And that's the sort of, theme of this, which is you're going from this sort of rules-based hurdles to be overcome to this sort of discretionary thing. And
yeah,
the law here is giving, it still gives you protection, that decision maker protection around that discretionary judgment they're making it harder to judicially review it, making, in a sense, you know, in maybe less accountable as a result of that. The argument would be these are democratically elected people, so it's much more accountable in that sense. But at the moment, you have a very clear process on how you reach decisions, and we're kind of moving away from that. So that's what we had to share with you all on these amendments. And should we move to questions then, the last few minutes that we have together? Katie, what's come in so far?
So we have a few questions. I'll start off, and then if any come in while I'm talking, I'll add them to the list. But to start, going quite back to the beginning, is it business as usual until the EDPs are created, or might there be intermediary impacts that people have to be concerned about?
So the law,
yeah.
sorry, Penny, go ahead.
You go. No, you go. Sorry.
So the law absolutely applies until these EDPs start getting drafted. And even with it, if you're covered by an EDP, as we said at the start, you could still opt out of it unless it's not made mandatory, and comply with the regimes as they currently are. So that's fine. However, is it having an effect? It's having an effect right now, I would say. Part 3 is having an effect right now. It's having a chilling effect on how nature markets are developing, how investment is going into things like nutrient credits. People are thinking about that carefully and making decisions already in anticipation of this coming through. So practically, I would say it's already having an effect, even if we are a little ways off. The
Yeah.
legislation getting royal assent, second legislation, the EDP is being drafted and then implemented. So that's my thoughts on that, Katie.
Thank you. How will this process achieve the aim of saving time in the planning process? Because to a lot of listeners, it seems like it's actually quite long-winded in itself, and it's a bit unclear how it's actually going to shorten anything in the immediate future, at least.
Well, when an EDP has been written, and we acknowledge that, yeah, it does look like that's going to take quite a while, and there's probably going to be people who want to challenge it, and it is bound to take a long time. I would say months, if not a year, to get the first EDP up and running. I'm sure Natural England will be trying to do it quicker, but so once the EDPs are written, then if a developer does want to just pay and go, then they can potentially do that. So once it is up and running, that will be possible. But so potentially, it has that advantage for developers. But of course, a development will have lots of different impacts on different things. So a developer might have a site where they've got nutrient neutrality issues, but also great crested newts, maybe some badgers, and possibly, I don't know, a recreational impact on an SPA somewhere nearby. And let's say there are those 4 impacts from this one development. There may only need to be an EDP for one of them.
Yeah.
So, then the developer's got to think, well, we've got to pay all these ecological consultants to help us with the rest. So do we just go the old route with the first one as well? If there's a nutrient EDP, do we actually just pay and get that out of the way, or do we somehow do a normal calculation budget and find someone who can sell us some credits? That's the difficulty. So actually, I think in the medium term, short term, medium term, there's going to be lots of work for ecologists who are trying to help their clients understand how to best address and cope with these myriad of options. It's a bit like when we had district licensing, when we first came through, I think ecologists thought that they would lose their work. But actually, I think there's always been a role for ecologists to, advise their clients on the different options, which I think is definitely going to be a big deal in this Part 3 issue.
Right, we've had a few more questions come in. There's a couple about kind of how this relates to local environmental policy. So in particular, how does a central centralisation of kind of environmental law align with moves that have been made over the last couple of years to kind of devolve more of those policy making decisions
Yeah,
powers to local government?
yeah.
And do you think the LNRS and EDP, that will play a part in EDPs and even the land use framework, which is being considered at the moment?
Yeah, I mean, ideally, EDPs will be drafted with all of that in mind. Local nature recovery strategy, absolutely in mind. But you're right, and Saeem, the webinar last week really pointed on that, and I thought that was really interesting because they were giving insights from a local authority perspective as well on this. Yeah, absolutely, that's something that local authorities are concerned about, that these EDPs could cut through in terms of how locally they're trying to address problems. And of course, a real concern around that, and some of the hoo-ha over the summer of this part 3 was around this, was, well, if you're benefiting sites elsewhere, the features, but in another location, um, and so that you could get the continued and ongoing and irrevocable degradation of protected sites in certain locations because it's just deemed, or give up on that, we'll go and prioritize something else, and that may be absolutely contrary to what locally they're trying to achieve. Is that your thoughts on that, Penny?
Yeah, I mean, I think there are attempts to try and bring the two together. For example, when the EDP is written, they have to have regard to the
Yeah.
local development plan, the local nature recovery strategy. It's all kind of there. It's sort of ticked off in the legislation, but how it will actually work in practice is anyone's guess, really. And the fact that Natural England will have all this money and wants to farm it out in a strategic way, it does, that sounds good, but where and how will the local area fare in that choice of what they do? It's just not clear at the moment.
And a kind of couple of maybe final points, because I'm aware we're running short on time. And this is all to do with, you mentioned judicial reviews briefly earlier.
Yeah.
I had a question about the Wild Justice judicial review and legal challenge that's coming in, and
Yeah.
that's going to be heard in November.
Yeah.
So firstly, the question is, how do you think that's going to affect the passage of the bill, and whether you think it will have any sort of impact? But also, do you think there's a possibility that what government's kind of doing here is actually trying to limit the capacity for people to kind of JR these EDPs? If it's all based
Oh,
on
I
Matt
see.
London's opinion,
Yeah. Yeah.
how are people going to judicially review them, and what is the process for that?
So as far as just to clarify for everyone, the World Justice Challenge talked about there is that when new legislation is published that affects the environment, under the Environment Act, you have to provide the statement. That statement says whether you think it's compatible with environmental standards, whether it's going to reduce it or not. And of course, this came out with the statement saying, of course, it's wonderful because it's aspirational. We're going to do things better. It's a win-win, rhetoric. So it had that statement attached to it, and that's what Wild Justice is challenging, given that the OEP has said it's regressive, seeing as leading KCs have said it's regressive, and seeing as amendments being made to it to make it less regressive. So that's the context here. But of course, it's an opinion, and I think that's the key thing here. It's so much harder to judicially review an opinion. It'll be interesting to see how the judgment goes on that, and I don't know. It'd be interesting to see how the court grapples with that, because what we are seeing, as we were saying earlier, is this move from these sort of hurdles, procedural-based tests, to this sort of more discretionary test in the judgment of an individual, and that makes it inherently harder to challenge it because it's their judgment call on it, and that's what the government wants. It wants to avoid the grit in the system that is judicial review, and so changing the law to make it more discretionary and more judgment-based is a way to do that. Are those your thoughts, Penny, too?
Yeah, I don't think the Wild Justice JR will actually have any success. I'm sorry to say, I mean, in a way, because at the end of the day, the courts are very slow to replace an opinion of a minister with their own. They're not going to do that.
Yeah.
And as Richard says, it's a personal opinion that Angela Rayner gave. And, I think that is not it's very difficult to get a court to intervene in that situation. So I don't think that will actually stop this bill. No. Okay, any other questions? We're 5 minutes over, but we didn't want to stop and miss out on the questions. So apologies everyone that we overran a bit. Perhaps one more question, Katie, if you can see one. Or perhaps there aren't.
When an EDP is being drafted, is there a statutory consultation procedure that any will have to follow? And if not, do you think that's something that will be picked up in secondary legislation?
No, there is. Yeah, they have to consult. There's a whole section in the bill about that.
Yeah,
that hasn't changed. That was there originally.
Yeah, and we've only focused today on the amendments, but that's there. And I guess there will be second legislation, but in primary legislation, you've already got these steps.
Yeah. If anyone has questions that we haven't answered, please feel free to email us. I think if you go on to the next slide, Richard, we've got our email addresses. Yeah, so please feel free to get in touch with us if you've got questions. And we'll put this on YouTube as well eventually over the next couple of days probably. So then if you've got colleagues or whatever who you'd like to tell about the YouTube webinar, you can pass it on.
Yeah.
Okay.
Yeah. Good.
Thanks
so
everyone.
much, everyone.
Cheers.
Thanks a lot.
Bye.